The proper time to send in the letter is once the settlement has been formally accepted by the court and that 60-day window has opened up. But you do what you want. Hey guys, Tony Denaro here. Welcome back. I promised you last night that I would give you an update today on Monday's court proceedings. What is going on with Allegheny versus AMC? We do have some updates to talk about really quick. The plaintiffs, Allegheny, have filed letters of objection to the judge to hear Mr. Iocono or Mr. Tuttle's motions. In this video, we're going to go through the plaintiff's opposition to Brian Tuttle's motion to intervene. The one for Iocono is on much weaker ground, so it's really not even worth worrying about. Let's talk about the highlights of why the plaintiffs, Allegheny, are telling the judge, please don't let Mr. Tuttle intervene. I'm going to scroll through this and just read the highlights. You can put it on pause if you want to read the entire thing yourself. In item number 1, they just give a recap that the plaintiffs and the defendants on April 3rd had come to a tentative agreement on a settlement, and that would be 1 additional share of AMC for every 7.5 after the conversion and the reverse split. In item number 2, the plaintiffs say that Mr. Tuttle's motion is a de facto objection to a proposal settlement which hasn't even officially been filed with the court yet. And that is true. We're still waiting on that phone-in conversation between the plaintiffs and defendants' attorneys that we supposedly are going to be able to listen in on. That has not been scheduled yet. So the plaintiffs are saying, hey, Tuttle can't object to something, to intervene, when a settlement hasn't even been formally introduced to the court yet. They go on to say in item number 2, once the settlement is agreed to, accepted by the court, and scheduled 60 days from then, that is the appropriate time for Mr. Tuttle to lodge his objection, much like what Chance, the lawyer, said to us. And there's going to be more on that as we get further down into this letter, that the time to send your letters in or your objections is once the settlement is formally entered into the court. In item number 3, Allegheny's attorneys say that Mr. Tuttle has no basis for legal intervention and that his interests as a AMC common stockholder are already being adequately represented by Allegheny's attorneys. Allegheny's attorneys are saying, look, we already did the work. We already looked through all the discovery. We've already researched all the case law. We came to an agreeable settlement with the defendant's attorneys, and it is in everybody's best interest to move forward with that settlement agreement. In item number 4, Allegheny's attorneys say that intervention here would open the floodgates to many upset AMC retail stockholders, maybe tens of thousands of them, who would be tempted to prematurely present their opinions on the merits of the action before the settlement approval proceedings have even happened. This is, again, going back to what Chance, the lawyer, said. The attorneys here are telling the court, this is not the time to be hearing from all these people when we are already here representing the class. Such sentiment should properly be lodged following dissemination of a notice about the class settlement through filing of an objection to the proposed settlement. What that means is the proper time to file your objection is once the settlement hearing has been scheduled and that 60-day window has been set up. Again, repeating, the plaintiffs are basically repeating what Chance, the lawyer, told us on the live stream the other night. I'm not telling you what to do. You can send in letters whenever you want, but not only did Chance, the lawyer, say that, but here the attorneys from Allegheny are even saying the proper time to send in the letter is once the settlement has been formally accepted by the court and that 60-day window has opened up. But you do what you want. Items number 5, 6, and 7, the plaintiff's attorneys are asking for denial of the motion to intervene. They lay out a couple of reasons for that, including in number 7 that Mr. Tuttle identified no statute giving him a right to intervene. Number 8 says Mr. Tuttle's interests as a stockholder are already represented by Allegheny's attorneys, representing the class. In number 9, Allegheny's attorneys are saying that Mr. Tuttle's motion is premature. that any motion to intervene should be deferred until after a settlement hearing, and this is particularly true given that the proposed settlement to which Mr. Tuttle objects to has not yet even been filed. Number 10 basically says the same thing with a lot of extra words, that allowing Mr. Tuttle to intervene right now would undermine the class action mechanism, the fact that Allegheny already has attorneys there representing the class. Number 11, they talk about how permissive intervention may be allowed in the court's discretion. However, they are arguing that permissive intervention would be inappropriate in this action. Number 12, they say Mr. Tuttle should not be allowed to intervene because he is not represented by counsel, and on that basis alone is not adequate to prosecute a class action under Delaware law. Number 13, Mr. Tuttle's chief complaint is that he wants the court to adjudicate the case on the merits of his claims. However, the plaintiff's attorneys point out that the law in Delaware favors the voluntary settlement of contested issues, and as we know, a settlement has already been preliminarily agreed to. What were Mr. Tuttle's allegations that have no merit? I've talked about them a lot over the last month or so. He says that AMC violated Delaware General Corporation Law, Section 242B2. I've already done videos on this a month or more ago. I'm not an attorney, but I didn't see any violation, and here the plaintiffs are saying they already looked into this, and they don't see a violation of that either. These are some of the best corporate attorneys out there that are knowledgeable of Delaware law, and they are telling the court and Mr. Tuttle that there was no violation of the Delaware law. Plaintiffs did not assert this claim because it is not cognizable. As I've been talking to you guys for the last month or more, the plaintiff's attorneys, Allegheny's attorneys, are telling you right here that Section 242B of Delaware corporate law allows for a majority of a corporation's stockholders to vote as a single class. We already showed you the evidence of that. There was no violation of law here, and Allegheny admits it. If it is provided for in the certificate of incorporation, it's perfectly legal, and I showed you in AMC's certificate of incorporation where it was provided for. Plaintiff's attorneys finish up number 15 by saying, yes, like Tony Denaro said, AMC certificates of incorporation contain this provision. There was no law violation here, guys. Number 16, basically what they're saying is, look, we've already looked at all the risks and strengths of Mr. Tuttle's claims. We've already examined them along with all of the discovery items and the evidence. And based on looking at all that, this is how we came to our settlement agreement with AMC, the defendants. Number 17, the plaintiff's attorneys say that the award, $120 million, that one share for 7.5 shares that you own after the conversion and reverse split, is an excellent result for common stockholders, and that if AMC is able to raise money and pay down some of their debt, the accretive impact could even be worth well more than $120 million. Number 18, they're arguing that, look, there's going to be a settlement hearing. It's going to be scheduled. Mr. Tuttle will have time to review it. He'll have full and fair opportunity to object without any need for premature intervention that would undermine the class, what Allegheny's attorneys are there trying to work out on everybody's behalf. For the foregoing reasons, Allegheny's attorneys, the plaintiff's attorneys, this was not AMC that filed this. Let's be clear. Allegheny's attorneys respectfully request that the court deny the motion. Now, Mr. Iocono, they really just trashed his letter because his basis of argument was, if the court doesn't let me intervene, it's going to ruin those protective puts that I have out there. And they just trashed that argument. Look, buddy, we've been working hard on getting a settlement. And just because your little investment plan didn't work out, your little strategy, that is no basis for an intervention. At any rate, that is what I got for you today. Hope this was helpful. Hit that like button, share the video. I am Tony Denaro, and I will see you on the next one as soon as we have another update.